Mr. Dunning.
My Lord, in my respectful submission, the Court of Appeal and the learned judge at first instance reached the right overall conclusion, and this appeal should be dismissed. And specifically, I make 6 broad submissions. First, on the construction issue. On the face of the letters of credit, the debt under them was due by Crédit Agricole either solely to the CBI, as the majority in the Court of Appeal held, or alternatively jointly to the CBI and SOMO, as the judge at first instance held.
And either will do for your case.
And either will do.
Right.
And we say that, and obviously I will develop this in more detail, but we say that in particular, in light of the 3rd and 4th last paragraphs on what we've called page 2 of the letters of credit. That is to say, the one that begins, we...
A and B.
Yes. The third last is the we hereby engage paragraph, and the one prior to that. And we say that those 2 paragraphs have to be read...
The other one being the one that begins, provided all terms and conditions.
Yes, ma'am.
Right?
Yes. And we say those 2 paragraphs are critical to the outcome on the construction issue, and they have to be read together. There's no inconsistency between them. It's not a question of the first one referring to SOMO's account and the second one referring to the CBI's account. They both refer to one and the same account. They are consistent, and we therefore say that SOMO and the CBI were joint promisees, but there was only one payment obligation when those 2 paragraphs are read together and consistently, namely to make payment to the CBI in New York into the Iraq oil proceeds account in its name at the Federal Reserve Bank, and only one of the promisees, the CBI, was entitled to benefit from that promise by suing in debt.
So your primary submission is joint obligation rather than sole obligation, is that right?
It's a joint promise which benefited only one of them insofar as only one of them could sue in debt.
But is your primary submission different from the ground on which you succeeded in the majority view in the Court of Appeal? They said CBI is the sole person entitled.
Yes.
I appreciate that may be your alternative point, but it's not your primary point, as I understand what you've just said.
That's right. But it really makes no difference. I don't have a strong preference between them.
But what do you mean when you say it's a joint promise, but only one could sue in debt? Which one? Either?
No, only the CBI.
Yeah,
was
the CBI.
Only the CBI.
I see.
Now, obviously, I'll come back to develop these points.
Yeah.
Just briefly, though, confirmation, which Mr. Pollock spoke about, is a red herring here, because there was no confirmation. It's common ground, there was no confirmation of these letters of credit. And therefore, the clause below that, special instructions, which applies if there has been a confirmation, was not triggered. And we can disregard that in the sense that...
We can't disregard it when construing this document.
Not disregard, I was going to say, in the sense that it doesn't apply. Obviously, it's still part of the document when one is construing it as a whole. But this is an unconfirmed letter of credit. And the bank, the CBI, was therefore acting as an advising bank. I don't know whether Mr. Pollock's glossary has reached my Lord Clerk yet, but it was an advising bank rather than a confirming bank.
But you agree that the special clause, special instruction to Central Bank of Iraq is posited on the assumption that it will have confirmed?
Yes, the special instruction is triggered if there is a confirmation.
Is it?
And there was, and my point was that there wasn't a confirmation.
Why is it only triggered on that? Wouldn't the Central Bank of Iraq, if it was prepared to do so, be entitled simply to accept the documents if they were in order? wouldn't it actually strictly be obliged, perhaps?
No, well, I
In
don't.
which case that promise to reimburse it would apply?
No, an advising bank can make a separate engagement with the.
No, I'm not suggesting it was,
Yeah.
but this isn't an engagement. It's just instructions upon receipt of your confirmation you have taken up the documents in conformity with the credit terms. So,
Yeah.
I mean, does that postulate that the central bank has necessarily agreed to take them up? It postulates that they have taken
No,
them
I
up.
see that point. I see that.
Well, they could only do so if there was an agency relationship with Credit Agricole.
Yes.
That would normally be a confirming relationship. I suppose you could, in theory, use somebody without taking his personal engagement as your agent to accept documents for you. But is that what you say happened here?
No. They didn't add a confirmation.
No.
They did take the documents.
Was there an
but
agency
They
relationship?
didn't.
Isn't this an authority? This is indeed an indication they will be taken up when they're presented in Baghdad, which is the only place where central bank is, isn't it?
That's right.
But does any of that matter? We're construing this document. We're not inquiring what happened.
Exactly. That's my point. That doesn't matter.
Yeah.
What we're concerned with are the two paragraphs that I say have to be read together, the earlier ones. I'll come back to this.
Fine. Anyway, we're holding you up because you're developing.
No, but my point is confirmation is really a red herring, and we can come back to that. And I do say that to answer one of the questions that was just put to me, that the analysis of Lord Justice Briggs at paragraph 60 is correct. And I do say that the short answer to this case is that no actual money is payable to SOMO under this letter of credit. And we say that for that reason, the judgment or the analysis of Mr. Lord Justice Morbick is paradoxical, because what Lord Justice Morbick has held is this. He has said the debt is owed to SOMO even though no money can be paid to SOMO under this letter of credit. But on the other hand, the debt is not owed to the CBI even though the money must be paid to the CBI.
But is that so very odd? Because if you have the beneficiary, in the traditional sense, of a letter of credit will very often specify an account in the name of somebody else to whom the money should be paid. It doesn't follow that this isn't a mode of discharging a liability to that beneficiary as opposed to the bank or to the institution whose account it is.
I accept this is a mode of discharging the liability of the buyer to pay the purchase price.
Yes.
I absolutely accept that. But the question here is, what are the nature of the obligations of the bank which discharge the buyer's liability? And my submission is that it is paradoxical for Lord Justice Morbick to hold that the debt is owed to someone whom payment cannot be made, and the debt is not owed to the person to whom payment must be made.
But it can't be that uncommon for somebody who's owed a debt to direct payment to a third party for all sorts of different reasons.
Well, no, but if you do it in the instrument which creates the debt, that is the feature of this case. It's not a separate assignment.
No, I see.
But it's all contained in the one instrument. We say that, and perhaps we should just look at.
But your submission seems to beg a large question about the capacity in which CBI was receiving this money, something which would depend on what arrangements existed between CBI and SOMO, about which the instrument is silent.
Well, and if that's right, my lord, then that's taken care of by my second submission.
Right.
But I'm only on what is apparent on the face of the document at the moment. But we do say on the face of the document that Lord Justice Briggs was correct, where he said, and it's paragraph 60.
Yep.
page 21 in the electronic bundle, and it's also page 21
Yeah,
in the core bundle.
yes.
Tab 2 in Appendix
Yeah.
1, core
So
documents.
paragraph 60, yeah,
Paragraph 60,
same bundle,
where he says this, standing back,
same bundle.
where a contractor X promises
20.
X and Y that he would pay a specified sum of money to Z and not Y, then without more he makes Z his creditor and confers only a right upon Y to claim damages from X for any loss which his failure to pay Z causes Y. I say without more revisedly because there may be material both inside and to the extent admissible outside the four corners of the contract, which show, for example, that the real creditor is Y and that Z is merely his agent. In the present case, the requirement to construe letters of credit independently of the transactions giving rise to them effectively excludes recourse to outside assistance. Now that's
Looking at condition B.
I'm sorry.
That's looking at condition B.
Yes.
Yep, yep.
That's looking at, well, I think he's looking at both of those paragraphs, because he held that your account meant the CBI.
Oh, I see,
CBI.
you're quite right, yes.
So, and Mr. Pollock, rather than the man on the Clapham omnibus, Mr. Pollock posited a new test of the bank clerk in the basement of the bank. And we say, if you ask the bank clerk in the basement of the bank, who is this letter of credit owed to, he would clearly say to the CBI, because that is the person to whom the payment is to be made into its account. And SOMO is not entitled to give any instructions of any sort in relation to the disposition of the debt. Now, I'll come back to this, but if we're right about this, then the requirements of CPR 72 are not satisfied, and there can be no receivership order or third-party debt order because there is state immunity, as Mr. Pollock accepts.
Yep.
And there was an issue, just in parenthesis, there was an issue of consideration for the promise owed to the CBI in the Court of Appeal, but that has been conceded and doesn't rise here.
Well, it's been not taken rather than considered.
Well, it was conceded in a letter. I mean, we don't need to go to it, but it was a letter after the permission was given to this House. Now, second main submission is this. This is where, to answer my Lord Sumption's question, one does then have to inquire into the relationship between the CBI and SOMO as to their respective entitlement to the money. And we say this, that on an inquiry which has to be made when a third-party debt order is to be made under Part 72, the court is entitled and indeed obliged to inquire into the position as between the judgment debtor and any other person involved to see whether the judgment debtor or that other person is in fact entitled to receive the payment. And that is, for example, what happened in the ex parte White House case, which I'll come to in a moment. Now, of course, this is of no concern to the bank in the ordinary case. And this doesn't affect the position of the bank in any way. But the court is in a different position, because when the court is asked to make a third-party debt order attaching a debt, the court has to be satisfied that the person who is the judgment debtor is entitled to dispose of the debt. And it may turn out, for example, that the judgment debtor is not entitled to the third-party debt, and some other person has a better claim on it. Now, in the present case, there is a very strong indication, initially on the face of the letters of credit, that SOMO is not entitled to deal with the letter of credit proceeds. Not only is it expressly provided that the payment must be made to the CBI's account, but it is provided that that position is irrevocable, that the proceeds of the letter of credit cannot be assigned or transferred, and that SOMO cannot countermand those instructions in any way. So it is fixed in stone, if you like, under this letter of credit, that the payment must be made to the CBI's account. And on the question of entitlement to the debt, as between the CBI and SOMO, you are then entitled to take into account the relevant background, because this is not purely a question of contractual construction. This is going beyond contractual construction to ascertain the position inter se between the CBI and SOMO, and to see which of them is entitled to receive the benefit of the payment under the letter of credit.
Can that, is it conceptually possible for the question to whom you owe a contractual debt to be determined otherwise than by reference to the contract?
Yes. For example, if there's been an assignment in a separate instrument, or if there's a trust in a separate instrument. So, yes, clearly, if there are two instruments, there's the instrument creating the debt, and then there's a separate instrument of trust or assignment. The authorities are very clear that the court will look at the trust or the assignment before it makes the third-party debt order.
Yes, I see that.
No.
If you're asking yourself if you're asking, assignment and equitable interest in the money in a third party apart, if you are simply asking yourself to whom is the debt owed, unless it's been transferred to someone else, that's got to be a matter of construction of the contract, hasn't it?
It's firstly a question of construction,
Yes.
but then there is still this question of the relative entitlement inter se, and we say, my lord, it doesn't make a difference that it's all in one instrument rather than in being two separate instruments. There's the one instrument which both has a relationship between the bank and the receiving parties, but it also is reflective of their relationship inter se. But apart from the terms, you can then look at the background, the United Nations Security Council background and the position under Iraqi law, to ascertain that as between them, it is clearly the CBI which is entitled to receive the payment and not SOMO. So obviously I'll come back to that and I will develop that. But we say that is part of what a court has to do on a Part 72 order. It has to inquire into the relative entitlement to receive the debt as between the judgment debtor and a third party who has an interest in the debt.
But you say that this can be arrived at apart from this letter of credit contract. What is the Iraqi law which says that the payment must be made to CBI? Is it a law, or is it just some decision of the government?
No, it's the financial management law that we've referenced in our submissions, which was signed by Paul Bremner, who you may recall was the administrator of the Provisional Authority of Iraq, and has been accepted in this case as being the law.
I thought that would run out. I thought that that scheme had expired and that was of a voluntary decision to continue the same mechanism.
Well, that's on the international plane, but as a matter of international law, you'll see when I take you to it that the financial management law itself envisaged that there might be other arrangements subsequent to the United Nations Security Council regime largely being replaced. Would I just, in parenthesis, add that it wasn't completely run out because the 5% reparations to Kuwait were still payable, and therefore the arrangement was still a matter of binding as a matter of international law, quite regardless of the note verbal, under the United Nations Security Council resolution relating to reparations to Kuwait, which determined that 5% of the oil sale proceeds had to go to the Kuwait Compensation Fund. And that was still binding. It still is today, as far as I'm aware.
This is all proceeds. Who says that it is obligatory to not just deal with proceeds, but to deal with contractual rights? Is there some law which says that this form of letter of credit is obligatory if you're selling Iraqi oil? Because this is dealing with the matter before it becomes a proceed.
There isn't. I mean, as Mr. Pollock said, there's not a law. It was drawn up probably by the Americans as part of the regime that that Mr. Bremner instituted when he was in power in 2004, 2003, 2004.
So if that's right, there is no law on the basis of which we can say SOMO didn't own this debt. The only basis we can say is if this letter of credit divests it of the title to the debt because of the contractual arrangements made, then that is the position.
Well, can I show you? Well, can I take you? This is just a headline as points, as it were. But I'll come back to that. I will show you what the law and the note verbal say. The third headline point is that whatever is the correct construction of the debt, the third-party debt order or the receivership order would interfere with immune property of the Central Bank of Iraq, which is protected by sections 13 and 14 of the State Immunity Act, and there is therefore a statutory bar to making either of the orders.
What is the immune property for the purpose of that submission?
Well, first of all, if it's the debt, then Mr. Pollock accepts that it's immune. If it's the shows in action, which is his
Wait, Mr. Pollock accepts it's immune.
Mr. Pollock accepts that if it's a debt of the CBI, then it is immune.
Yes, but the
If it
point
is
of my
not
question
a
was a
debt,
different one.
If it is,
What is the immune property
well,
which would be interfered with on your submission?
it's the debt of the debt owed to the CBI, if it is a debt on the true construction.
And if it's owed to the CBI?
And if it's owed to the CBI, yes, obviously.
Well, then you don't need to worry anyway, is it?
No, exactly. And then alternatively, if I'm wrong about that, and it's a shows in action for damages, the collateral promise analysis that Mr. Pollock advocates, then the shows in action for damages is property protected by the State Immunity Act, and the order would run counter to section 13(2)(b) because it would effectively destroy that property as a matter of English law at least, because the bank, as Mr. Pollock says, the bank would have a cast iron defence to any claim for breach of that promise. And I hope you received yesterday, we put in a supplemental note on this point referring to the quite recent decision of this court in the Belhaj case and the subject of indirect impleading. And we rely on that for the wide interpretation of section 13(2)(b). So on this hypothesis, just to recap, it's a shows in the bank has a shows in action for damages. That is property within the meaning of the State Immunity Act, and it is immune from being directly affected by any process of enforcement. And the precise words in section 13 are immune from being subject to any process of enforcement.
But the sense in which it is affected, you have to submit, don't you, that if the effect of levying execution on a debt owed to A is to reduce the value of the assets belonging to a sovereign entity, that is a sufficient basis for not being allowed to levy execution.
Well, I wouldn't put it that way.
Well, no, I
I
don't
would
suppose
put it
you would.
slightly
Isn't
differently.
that the logic of it?
No, if there is an instrument which creates a debt owed to A and a collateral promise connected to that Mr. Pollock says it's a collateral promise that that debt will be discharged to the central bank, and the debt is attached in such a way that the promise is discharged, the collateral promise is discharged, then that collateral promise is being directly affected by the process of enforcement. It's being rendered completely useless and valueless.
Yes.
It is a complete
Well,
defence.
I see that is the effect, but it is a knock-on effect of the levying of execution upon an asset of somebody else.
Yes.
And on that view, you're attaching an extraordinarily wide meaning to Section 13, aren't you?
Well,
This is carrying Section 13 away from the realm of execution and into the realm of knock-on commercial consequences of execution on third parties.
It's not a commercial consequence. It's a legal consequence, my lord, because
Right,
it's
let's
a
just call
legal
it a consequence.
It's a legal consequence because, as I understand it, Mr. Pollock's argument is that if this is a debt owed to SOMO and it is attached, then normally the bank would owe a collateral promise to the CBI to make payment to the CBI in New York. But it will be discharged from that promise by the making of the attachment by the English court.
Because if the debt truly belongs to SOMO, it will have been satisfied.
Yes.
But
And we say that in circumstances where the collateral promise and the debt are intimately connected and created by the one and the same instrument, it would be making an order which, to all intents and purposes, destroys that property of the central bank. That shows in action for damages would be destroyed because Credit Agricole would have a complete defence in the future, whereas it would otherwise have had a liability to the central bank for not making payment.
But CBI, I mean, this is all a bit metaphysical. CBI wouldn't suffer any loss, would they? Under this collateral term, the people who suffer loss would be the government of Iraq, wouldn't it? Or is the postulate that the money is again, I suppose in the first instance they'll belong to CBI, you say, they'll go into its bank account or a bank account and be held for it, even if it holds them for someone else.
Yes, they would have legal title to them in once they've hit the account in New York. But my point is obviously to do with what the position is in London. And the Credit Agricole, if sued in London on the collateral promise, would say in those circumstances, we don't have to pay because there's been a court order.
I don't want to take you out of order, but if the debt is owed to SOMO and not the CBI, and if Credit Agricole does not have a force majeure defence, I wonder at some stage in your submission, it doesn't have to be now, you could explain to me what is the measure of damages that would be available to CBI, because at the moment I don't see what it is.
Well, okay, I will try and revert to that. Now, obviously, our primary case is that you avoid all these questions of what damages would the CBI be able to recover, because the CBI is entitled to recover in debt. And you read those two paragraphs together in the letter of credit, and they create a debt which is owed to the CBI and enforceable by the CBI as a debt. Now, then the fourth main headline issue we then come to is the lex situs point, and whether or not this court should follow the decision of the Court of Appeal in Power Curber or overrule it. And so far as that is concerned, we say it would be a retrograde step for the court to overrule the Power Curber decision. That rule is one of long standing now, more than 35 years. As far as we've been able to ascertain, it has not caused practical problems. It has been approved, it seems, in major Commonwealth jurisdictions, and we did a short further note on our researches on that yesterday as well.
Where is that? In the supplement? It's a second one, is it? Right.
Yeah.
Yeah. Yes, I did see it.
We submit that it's a rule that is well-founded in principle and as a matter of policy.
Do any of those cases, though, analyse the underlying rationale of the rule?
No.
I mean, they mostly simply say, well, that's what the English court said, well, Bob's your uncle.
They do. But that's absolutely right. But nevertheless, we see Singapore, Australia, Canada, I think there was one other country, saying that seems to be
Malaysia.
Malaysia and New Zealand.
And New Zealand, yes. And that seems to be the rule, and there's no criticism of it there. My Lord Neuberger, you asked this morning whether there were we have what the textbook writers have said about this. We have set that out in the case. Mr. Pollock has obviously referred to Dicey, but there are other textbooks, and there's a very interesting article by Dr. Pippa Rogerson from Cambridge, who...
I do. I remember citing it to little avail in Eram,
Yes.
Society Eram.
Anyway, those we can come back to those, but that's the position. It's not been found to be impractical. It's been cited as representing the law, and we say it's well-founded as a matter of policy, and that is it is not a question of judicial imperialism at all. It's the basis for it is the protection of the security of payment of the seller. Now, and the reason being that if you have this rule, the payment is likely to take place in the place either where the seller resides or which the seller has chosen in which to be paid. And in either case, it is fair that he takes the risk of non-payment arising from legal risks in either the country where he resides or the country where he has chosen to be paid. So this rule is therefore consistent with the whole raison d'etre of letters of credit, which is to provide security of payment to sellers. There is something, to paraphrase what Mr. Pollock said, there is something special about letters of credit. They are meant to be the equivalent, as far as the law can do, as to cash in the hands of the seller. Cash in his hands in the place where he resides or where he's asked to be paid. And so there is something very special about letters of credit, and it would undermine the security of letters of credit if the place of residence of the issuing bank was the locus of the debt. And the Power Curber case itself is a good demonstration of that. There is one other connected point of principle. So sorry, just to go back one, we say if you have to choose between the interests of the seller and the interests of the bank, it makes sense in the context of letters of credit to prefer the interests of the seller over those of the bank. Mr. Pollock was holding up the spectre of the bank being under an order in one jurisdiction, possibly a different regime in another jurisdiction. We say, in this context, it makes sense to protect the seller over the interests of the bank. But there is a connected point of principle, which is this. Whatever approach you follow, it should be a rule for the choosing of a citus which is based on the interests of the parties to the letter of credit, and not the interests of a stranger to the letter of credit, such as Taurus. Taurus is a stranger to these contracts, and its interests ought not to dictate the conflict of laws analysis. That should be in line with the interests of the parties to the contracts contained in the letter of credit. The fifth headline point is we say that the Court of Appeal was entirely right to decline to make a receivership order with extraterritorial effect, applying the approach described by Lord Justice Collins, as he then was, in paragraph 59 of Masry number 2. And that is so even if the debt is not immune central bank property under the State Immunity Act. And it is a fortiori if the proper law or the applicable law of the letters of credit contract was not English law. And finally, sixthly, if it is relevant to decide for the purpose of the receivership order what is the applicable law of the contract containing the obligations of Credit Agricole, then we say that both Mr. Justice Field and Lord Justice Morbick erred in holding that it was English law and not New York law. And that is the correct result, applying what has been called the displacement rule in Article 4.3 of the Rome I regulation, which is the successor to what was Article 4.5 in the Rome Convention. So this is the applicable law issue. As a matter of historical interest, the common law and the courts, when they were applying the Rome Convention, regarded this again as a policy issue which was for the protection of the seller, in order that his rights ought not to be interfered with as far as possible. You should choose the applicable law, which was consistent with the protection of the seller. And so the courts, both starting at common law, the courts held that the place of payment was the place which governed the applicable law. The courts then reached the same result applying the displacement provision in Article 4.5 of the Rome Convention. And the question for this court would then be, does the same result apply in the displacement provision under Rome I, which is 4.3? There's only one material change, that the word manifestly more has been inserted in front of the words more closely connected. But we say that these letters of credit are manifestly more closely connected with New York than with England, and therefore 4.3 should apply, and New York law should apply. And that, if you follow the analysis of Lord Justice Morbick, that is a yet further reason why no receivership order should be made, for example.
Yeah.
So, now, my Lord, I appreciate that the way that the issues interrelate is not necessarily entirely straightforward. So I have put it on one sheet if it's of any use. You may think it's otiose and it's all very obvious how the outcome is detected, flows from the issues. But if it would be of any assistance, I have a document, the structure of the issues.
Thank you.
Yeah.
So the first point is straightforward. If the debt was either owed solely to the CBI or to the CBI and SOMO jointly, then it's conceded that the State Immunity Act applies and therefore neither form of order can be made. The second point is, if, however, the debt was owed solely to SOMO and not to the CBI, the same result follows, and we say the appeal should still be dismissed, both limbs. This is 2-1. CBI was instead the recipient of a collateral promise, sounding only in damages and debt. Collateral promise is a shows in action for damages, which is still property within the meaning of the Act, and whether or not the collateral promise is subject to Mr. Pollock's implied proviso. And thirdly, that collateral promise would be subject to, in the sense of being directly affected by, a process of enforcement within Section 13(2)(b), if either of the orders were to stand. Then 3, even if you're against SOMO on 1, and you also reject the analysis on 2, the third-party debt order must still be set aside if the situs of the debt under the letters of credit was New York, following Power Kerber, or even if the situs of the debt is England, on the basis that under Part 72, the court must inquire into the issue of entitlement to the debt as between SOMO and the CBI, and as between SOMO and the CBI, SOMO was not entitled to dispose or otherwise deal with the debt. And for other reasons in relation to receivership, we say that that was a proper application of the Masry principles. The position would be a fortiori if the debt is situated in New York, or if the court decides that English law does not apply to the relevant contracts. So I hope that shows how the issues link up.
Thank you.
Turning then to the construction issue, we have set out in our case at paragraph 30 the terms of CPR 72, and this is electronic bundle 2665.
Thank you.
And page 82 in tab 6 of core volume 1.
Thank you.
And 72 starts with 7211. This part...
Sorry, can you give me the tab number again? 2-minute numbers.
I'm sorry, tab 6. If you're in...
Right. Paragraph.
Core volume 1.
This is the quote in your
Setting out
statement of case.
CPR 72, Page 2665.
Yes.
2665.
2665, Internal page 8.
So it starts with paragraph 1. This part contains rules which provide for a judgment creditor to obtain an order for the payment to him of money which a third party who is within the jurisdiction owes to the judgment debtor. And then in 72.2, 1A, it applies to the amount of any debt due or accruing due to the judgment debtor from the third party. And we've emphasised, as you see in paragraph 31, the words owes to the judgment debtor and due or accruing due to the judgment debtor. And we say that that means that the court has to ask itself, could the judgment debtor recover judgment in debt in his favour? And we respectfully adopt what Lloyd Justice Floyd said in Ferreira and Hardy about the relevant test. Now, this is in the Additional Authorities, Volume 1, Tab 16, page 103, which is electronic bundle 1940. And I can tell you, your lordships, that this was a very different case from the present one. This was a case where there was an attempt to obtain a third-party debt order over housing benefit being paid by a local council. And they sought to execute the judgment against the landlord's agent. And Mr. Herrera was the judgment debtor, and he was the landlord's agent to whom, in the past, the housing benefit had been paid. And I would invite you to look, please, at paragraph 12, where Lord Justice Floyd said, although and this is electronic 1943, page 106 in tab 9, in tab 16. Paragraph 12. Although the argument in the courts below seems to have focused exclusively on the question of whether a trust is to be imposed on the relationship between the landlord and Mr. Ferreira, there seems to me to be a logically prior question, namely whether the money held by the council can be said, using the words of CPR 7211, to be money which the council owes to the judgment debtor, or using the words of 7221A, whether there is a debt due or accruing due to the judgment debtor from the third party. If the council does not owe Mr. Ferreira the money, or there is no debt as between the council and Mr. Ferreira, then there is no debt which falls within the rule and which the third party debt order can attach. In this context, the rules must, as it seems to me, be referring to a civil debt enforceable by the judgment debtor. A further point made in the White Book commentary at 7221 is that a judgment creditor cannot, by means of a third-party debt order, stand in a better position as regards the third party than did the judgment debtor. Again, this seems to me to be self-evidently correct. A useful test must be whether the judgment debtor would be in a position to sue the third party for recovery of a debt. And so the question would be, if one applies that test, would SOMO be in a position to sue Crédit Agricole under these letters of credit for recovery in debt? And we say that the answer to that question is no. SOMO could not sue for recovery in debt in light of these letter of credit terms. The very best that SOMO could achieve would be an order that the bank makes payment to the CBI. But it wouldn't be able to recover a money judgment in its own favour, because that would be inconsistent with the express terms of these letters of credit. Nor, just trespassing slightly on the lockers, on the lockers point, nor could it obtain a judgment that it be paid in England. So if we're right on that, we say that that's the short answer to the point in relation to CPR 72. And we say that that means that this is property of the CBI, which is immune. Now, before I return to the express terms, would like, if I may, just to make some general observations on the approach to the construction issue. First of all, the UCP. The UCP, as you've seen, is a set of international rules that are commonly incorporated into letters of credit. But they are not a code, and they are not prescriptive. They yield to any express agreement in the actual letter of credit that is inconsistent with them. And if you've still got Mr. Pollock's loose hand up,
Yes.
and you go to the UCP,
Yes.
you'll see that on the fourth page,
Yep.
where there's a heading right at the beginning, Article 1, an application. And it says, these are rules that apply to any documentary credit when the text of the credit expressly indicates that it's subject to these rules. They're binding on all parties thereto, unless expressly modified or excluded by the credit.
Yes.
So they contain within them the basis for them being excluded.
Understand.
And we have the benefit of a very clear and short dictum on this very point of Lord Justice Mustell in the case of Royal Bank of Scotland and Casa di Risparmio, which is in the additional authorities bundle of volume 3 at tab 26, and the electronic bundle 2306. And I needn't trouble you at all with any of the facts of this case, but there's a very clear dictum on this particular issue,
Where do we find it?
and that's electronic page 2310, page 78
Yes.
in the bundle number, or 255 of the law report.
Yes.
And in the bottom right-hand corner, he says, as I see it, this case is founded on the proposition that the contractual relationship is dominated by UCP, that the obligation of the issuing bank to reimburse RBS derives solely from Articles 10 and 16, and that accordingly one should look there and no further to find the undertaking by the issuing bank to reimburse the accepting bank. I cannot agree. Undeniably, the uniform customs and practices have an important role in the conduct of international trade. They expound technical terms, they promote consistency, and they enable the parties to express their intentions briefly and without the need to negotiate and set out all the terms of the relationship at length. Nevertheless, whilst not belittling the utility of UCP, it must be recognised that their terms do not constitute a statutory code. As their title makes clear, they contain a formulation of customs and practices which the parties to a letter of credit transaction can incorporate into their contracts by reference. That being so, it seems to me that the obvious place to start when searching for a contractual term material to a particular obligation is the express agreement between the parties. If it is found that the parties have explicitly agreed such a term, then the search need go no further, since any contrary provision in the UCP must yield to the parties' expressed intention. If, on the other hand, the agreement is silent in the material respect, then recourse must be had to the UCP, and if a relevant term is found there, that term will govern the case. Now, we say, with respect to Mr. Pollock, that dictum is highly apposite in the present case. That is why it doesn't assist the appellant to say, as he does, that the named beneficiary in the letter of credit is the debtor who has control of this debt. Because if you go first to the express terms, and if on the true construction of the express terms there is a clear answer to who is the debtor, then you don't need to go any further, as Lord Justice Mustell said, and you don't need to look at the UCP. And we say there is a clear answer in the express terms.
Yes, but the application of UCP Article 1 suggests they're binding unless expressly modified or excluded by the credit. The credit document starts off in standard form with a description of the beneficiary of the credit, namely SOMO. And is it not legitimate to construe the meaning of the subsequent special conditions in the light of those provisions and the UCP, and ask, well, do these provisions expressly modify the UCP?
Well, my lord, I would say it's not necessary, because the relevant inquiry here is to whom is the debt owed. If one reaches a clear conclusion of that from construing the express terms, then anything in the UCP which is inconsistent with that would not advance the inquiry. If you hold that it's not clear, then of course you could look at the UCP.
But if we focus solely on the two special conditions A and B, I see the point that you make. But if you look at the opening gambit of the credit and see that it is a credit given to SOMO, you have to ask why, if they're not the debtor.
Well, there is a clear reason why, and that is to discharge the obligation of the purchaser to make payment either to SOMO or in a way that SOMO regards as discharging its obligation under the sale contract.
Well, they could have done that simply by saying, you'll discharge your obligation for the price by opening a letter of credit in favour of CBI.
Of course they could.
Yeah.
But
You say they did that by accident instead of in purpose.
no, not by accident, because this was not an accidental regime, and this was the way all the letters of credit were done, as you've seen from Mr. Pollock shown you the standard form. This was not a one-off accidental transaction. This is the way that they did it all the time in order to comply with the UN Security Council resolutions and Iraqi law.
If it was deliberate, then why not make CBI the beneficiary?
They didn't, as Mr. Pollock said, they didn't draft it as clearly as they might have done. But we say it's still clear enough, although it's
pretty fundamental, surely. I mean, I agree that the drafting of letters of credit is a very accident-prone process. But if you actually start out by identifying the wrong beneficiary.
Well, I'm just about to come on to another aspect of the construction, but perhaps I should just do that, and I think that might answer the question. But let me get to the end point, and then I'll go back through the steps. The normal principle that special terms are given greater weight than general ones applies to letters of credit. It's a Latin maxim, generalia non specialibus derogant, applies just as much to letters of credit as it does to any other contract. And let's take that was the end point. But if I can just take you through it step by step, there ought not to be any dispute, my lord, that letters of credit are construed according to normal rules of construction of contracts, subject to one qualification, which I will come to.
Yes.
And the authority for that is a short passage in Jack on documentary credits, which is in Additional Authorities, Volume 4, Tab 44, page 67, Electronic Bundle 2507. And this is paragraph 1.17 in Jack, and also 1.18, which comes immediately afterwards. It's headed The Construction of Documentary Credits and the Relevance of Banking Practice, and he starts by saying, despite their special nature, documentary credits subject to English law should be construed in accordance with the ordinary rules of contractual construction. And then he refers for example.
Familiar authorities, yeah.
Yes, to familiar authorities, which we're very familiar with. So, one of the ordinary rules of contractual construction, and I probably don't need to turn it up, but if you wish to look at it, it's in Authorities, Volume 4, Tab 46, page 80, is Lewison on the general rule that special terms are given greater weight than more general ones.
Yeah.
The Latin maxim that I won't repeat. So that is why we say, if I go back to my Lord Hodges' question, I think, well, what about the general terms? But we say that it's a normal rule of, there's nothing magical about letters of credit. They're not exempt from the normal rules of construction. And you apply the special terms and give them greater weight than the more general ones. And particularly, of course, one gives them greater weight than terms that are simply incorporated by reference.
Greater weight. I mean, basically, we've got to try and read the contract in a way which makes all the terms consistent with each other.
Yes.
What does greater weight mean? If they're inconsistent and you can't marry up the general with the specific prevail. But apart from that, what else do you do?
Well, I think it means this, my lord. Mr. Pollock, I think that he didn't put it this way, but this is effectively what he was saying, is in letters of credit, the money is normally due to the beneficiary. In this case, the beneficiary is SOMO, and therefore the money is due to SOMO because it's named as a beneficiary.
Yeah.
That's effective. It's a sort of syllogistic argument. It's normally beneficiaries are the creditors. SOMO is the beneficiary. Therefore, SOMO must be the creditor here. And we say that may be true as a generalism, that the payment is normally due to the beneficiary, but it doesn't tell you anything about the terms of this specific letter of credit.
I see the point, but the fact is that the bank on instruction has chosen to name SOMO as the beneficiary.
Yeah.
And I don't really see how the dichotomy between general and special terms arises in that case, because our task is surely to reconcile the opening paragraphs of the letter of credit with the special conditions on which you found.
On top of which, the important words that can be said have been added after in favour of oil marketing company SOMO. So those words were inserted.
Yeah. Well, I don't resign at all from the proposition that you have to construe the document as a whole, obviously.
Yeah.
But you should, in my respectful submission, give greater weight to the special provisions, because those have been specially those have been denoted as special conditions. They've been given some greater weight than the more formulaic provisions, if you like, which come at the beginning. Those are the ones that the parties have specifically addressed their minds to.
I still have some difficulty with the greater weight point. I mean, they might add something that's pretty minor, but something that's very important to the parties or is worth including. But you won't present it on Friday afternoons. But
I see that.
You wouldn't necessarily give that, quote, greater weight.
No, but on this particular issue, which is, does the mere naming of SOMO as the beneficiary mean that the debt is due to it?
Well,
we
the
say
word mere rather loads that question, doesn't it? Does the naming.
All right, does the naming of it. But if one formulates the issue.
But they chose, but that's my point, that if you that's why I don't find it very helpful. They chose to name SOMO. That is an added thing to the contract. It's not standard form. It doesn't say oil marketing company SOMO on the standard form. Yeah. So we have to give that great weight, the fact that they name SOMO.
Yeah.
But anyway, there we are.
But they have entered into a contract where, which is, as I say, in a sense written in stone, because it's not assignable, not transferable,
yeah.
no instructions to the contrary can be given. And the only payment that is talked about is a payment to the CBI's Iraq oil proceeds account in the Federal Reserve Bank in New York.
Well, clearly they have to be given an appropriate weight. That must be right. Yeah.
And
Greater weight.
so those are some general points in relation to the construction of the letter of credit. And if I can now turn to the specific points, and I'm looking now on page 55, or what we call page 2, and on the special conditions, the first thing to which I would draw attention, I've referred to it a number of times, just above halfway down the page, this letter of credit is not assignable and not transferable. And then we can skip a few paragraphs, and then we get the paragraph that begins, provided all the terms and conditions of this letter of credit are complied with, proceeds of this letter of credit will be irrevocably paid, so this is part of what I call casting it in stone, irrevocably paid to your account with the Federal Reserve Bank, New York. Now, and then it says, with reference to the Iraq oil proceeds account. Now, just pause there. I'll come back to the next sentence in a moment. But your account must mean the CBI account, because when you read that together with the next paragraph, in the fourth line, it says, as specified to credit CBI account with the Federal Reserve Bank, New York. Now, it would not be sensible in my submission to read those two paragraphs as being inconsistent. One asking for payment to SOMO's account and one asking for payment to the CBI's account. They should be read together, and your account should therefore be read as meaning the CBI's account. And this may be one of the situations, if there is any that is in my submission, that's clear. But if there is any ambiguity, this may be one of those situations when one is entitled to refer to the background in order to clarify the ambiguity.
It would only be the background which constituted common knowledge between the parties, wouldn't it? So don't you have to say that the background would presumptively be known to Credit Agricole's documentary credit department?
Well, if I do, I can't satisfy that. But it is a matter of public record from the UN background that this is the account of the Central Bank of Iraq.
Well, many things are matters of public record which document clerks, like judges, don't know.
No, of course, and I accept that. Yeah, but before we get to that point, whether there's an ambiguity or not, I submit that it is very clear when you read the two paragraphs together that
in the second paragraph, the we is Credit Agricole, is it?
Yeah.
Yes.
And the beneficiary is
SOMO.
And then you have the Central Bank of Iraq.
Yeah.
You say they've agreed to pay it into that account.
Yes.
And reading the two paragraphs to make sense and mutually consistently, your account must be a reference to that account.
Well, they can't irrevocably agree to pay one sum to two separate accounts.
No, they can't.
That's your point.
Yeah, you've got to read it together. And obviously, this again, it could have been a little bit more neatly drafted if it had been drafted by those who are sitting in this court, for example. But we're faced with what we're faced with, and it's tolerably clear where the payment has to be made and to whom. And that is a critical point. And the only other critical point is none of that has got anything to do with the letter of credit being confirmed.
I mean, I suppose you would say in a similar way, the second, what's been called B, has to be read as an irrevocable commitment because of what's in A.
Yes. And sorry, and I've skipped over, of course, the second sentence of that paragraph, which is these instructions will be followed irrespective of any conflicting instructions contained in the seller's commercial invoice, that's obviously a reference to SOMO, or any transmitted letter. And this again is part of why I say it's written in stone. I'm obviously using a metaphor. But you've got not assignable, not transferable, irrevocably to be paid to the CBI account, and we won't take any notice of any conflicting instructions. Now, we do say that those terms that I've just drawn attention to are the guts of this letter of credit. And there is a fundamental point between myself and Mr. Pollock here. We say that those terms are not the mechanism for discharging the debt, they are the very description and creation of the debt. It's very artificial for him to say that somehow there's a debt that's owed to SOMO, which in this very one and the same instrument, there's a separate debt owed to SOMO, but it is to be paid to the CBI. This is one instrument, and the only payment that can take place is a payment to the CBI's specified Iraq oil proceeds account in New York at the Federal Reserve.
Are you saying in practice, I suppose you say it depends which argument you take, whether it's joint or simply in favour of CBI, but what about the words in favour of our marketing company SOMO at the beginning? What do they mean on your construction?
Well,
what are they doing? Are they a mistake?
No, the letter of credit.
No,
that's not a mistake, because what that means is here is our letter of credit, by which the Shell, Singapore, are discharging their obligation to make payment under the contract that they made with SOMO. So it is in that sense a letter of credit in favour of SOMO, because there was an underlying sale contract, and this letter of credit discharges the obligation to make payment under the underlying sale contract. So it is in
favour of basically means to satisfy our obligation to.
Yes, to satisfy the obligation of our customer,
correct.
to make payment for I think it was about $200 million worth of oil. That's effectively what it means, yes.
Thank you.
Now, without labouring the point too much, there are 10 points I would like to draw out of these terms that I've just been running through.
Very well.
And firstly, under these letters of credit, the bank is neither obliged nor entitled to make any payment to SOMO at all. Secondly, under these letters of credit, the bank is neither obliged nor entitled to make any payment in England at all.
Yeah.
Thirdly, the bank is not contractually required to do anything in England. It is contractually required to make payment in New York.
Yep.
Fourthly, Crédit Agricole promised both SOMO and the CBI that it would honour a compliant presentation by the seller and make payment to the CBI into its Iraq oil proceeds account at the Federal Reserve Bank in New York.
I've seen that.
Fifthly, that promise by the bank was irrevocable, and it required that payment could only be made into the CBI's Iraq oil proceeds account.
Well, that's reading B with A, effectively.
Okay, I'm sorry.
Is that right?
Yes. 6, despite being named in the letters of credit elsewhere as beneficiary, under these special express terms, SOMO was not in fact permitted to receive the proceeds of these letters of credit as they were to be paid to the CBI's account. Seventhly, it was not even permitted to give any instructions as to their disposition or as to the place of payment. Eighthly, the letters of credit could not be assigned or transferred. Ninthly, Crédit Agricole could only discharge its central obligation under these letters of credit by making payment to the credit of the CBI at the CBI's specified Iraq oil proceeds account at the FRBNY. Anything else would not be a failure of mechanics, it would be a failure to discharge the debt. And conversely, Crédit Agricole could not discharge its obligation by making payment in any other way or to anyone else or into any other place. And it could not discharge its obligation by making payment to SOMO or as directed by SOMO.
Or
Now,
if it paid pursuant to a third-party debtor order, would that be a discharge?
well, in law, it would discharge a debt if one was owed,
Yeah.
but it would be tantamount, in my submission, for the reasons I've given, to rewriting the terms of the debt.
So you submit that if the third-party debtor order was enforced, Crédit Agricole would not be discharged, but would have to pay all over again under the contract. Is that the case?
Yes, because the true analysis is that this is a debt owed to the CBI for the reasons, and it cannot be discharged by making payment to SOMO.
Well, aren't we assuming for this purpose that it's a debt owed to SOMO, but which can only be discharged by payment to CBI?
No, I'm not assuming that, with great respect, my lord. I'm not accepting it's a debt owed to SOMO at this point of my submissions.
Right, I understand.
Now,
What would happen if...
and just if I could just go back to the question, because there is a point underlying that question, I think, which is the law is very clear, my lord, that if an issuing bank makes payment otherwise than strictly in accordance with the terms of a letter of credit, it risks having to pay twice.
Yeah.
And I can give you a reference for that, but it's obvious.
You are not submitting that on the footing that the debt was owed to SOMO, compliance with a third-party debt order would not amount to a discharge.
I'm not on that part of my submissions at the moment. I'm still on the part of the submissions by saying that the debt is not owed to SOMO.
Yes.
What would happen if Shell turned up at SOMO's offices with the requisite 200 million and SOMO accepted them? Would that be a breach of contract to CBI?
I'd have to think about that, my lord. I'm not. It's so much outside what would normally happen. I entirely agree with Mr. Pollock.
One can have a less far-fetched example.
I think Mr. Pollock and I agree, by the way, that the way that these letters of credit were in fact discharged was an instruction was sent to JP Morgan in New York, and then it was a transfer via Fedware.
Yes.
And I should just point out, of course, that we are concerned with 2 letters of credit, but the vast majority of the money was paid, and it's only about 9 or 10 million which has been stopped. So the rest of it has operated in that way in relation to these letters of credit.
That's all that was needed to stop. to meet the arbitration award.
Yes, of course. I'm not complaining. I'm just saying that it has operated the way that Mr. Pollock described. So the authority, if you want an authority that the bank who pays the wrong person will have to pay a second time, it's Jack, and the reference is given in our case. So that is our case in a nutshell. We say that if you apply the test that Lord Justice Floyd applied, paragraph 13 in the Ferreira case, then can the judgment debtor recover judgment in debt? Then the answer must be no, because SOMO could not obtain a judgment in debt in its favour under these letters of credit, because payment was not to be paid to it, still less was it to be paid in England. Now, and we do say, and I have meant this point, but I'll just repeat it once, that it is illogical of Lord Justice Morbick to say that the debt is owed to the person who is not entitled to receive payment, namely SOMO, whereas the person who is entitled to receive payment, namely the CBI, is not owed the debt, but only owed a collateral obligation sounding in damages. We say that Lord Justice Briggs' analysis is to be preferred. I've already taken you to paragraph 60, but in the subsequent paragraphs, at 61 to 63, Lord Justice Briggs also deals with the other points that have been made, and in 63, for example, he deals with the point about the beneficiary, and we adopt what he's said there. I think the only other
61 to 63. You said yes.
Paragraph 60 of Lord Justice Briggs' judgment. At
Yeah,
page
we looked
20.
at that. We looked at that before. Yeah.
Yep. 63.
63, right?
Yep. Where he deals, he explains how he rationalizes the use of the word beneficiary. The final point, and I probably already dealt with this, is that Mr. Pollock talks about the need for confirmation, but none of the terms that I've focused on in the special terms are conditional upon there being a confirmation. So if I may, I'll move on to the second point, which is the issue of entitlement to the debt as between the CBI and SOMO. If I win on the first point, I don't need this second issue.
No. If you win on the first point, the appeal's dismissed.
Is
at the
over.
end of it. Yeah.
Yep.
Understood.
Now, this second point, it would never be a matter of concern to the bank. That's one point I want to make straight away. The bank would never need to inquire, is it the customer or is it the bank who, I'm making payment to a particular account, who's entitled to this debt? That would not be of any concern to the bank. So long as the bank makes payment strictly in accordance with the letters of credit, then it's safe and it won't have to pay twice. But when the court is asked to make a third-party debt order, the court is in a different position, because the court does now have to understand whether the judgment debtor is the person who is entitled to deal with the debt, as between the judgment debtor and any third party. So, for example, the debt can be charged or assigned, or it could be the subject of a trust. Now, as I said earlier, one can see how that works where there is one instrument creating the debt and then a separate instrument with a charge or an assignment or a trust. The only difference between that case and the present case is that in the present case, everything is in one document. we say that still exactly the same need arises to ascertain, as between the two promisees to that single instrument, which of them is in fact entitled to deal with the debt. So whatever may have been the pure construction, the background material is relevant and admissible when it comes to this second way of putting this issue, if I need to go this far.
Yep.
Now, first of all, we find indications as to the position between SOMO and the CBI on the face of the letter of credit itself, because as we've just seen, the money has to be paid to the central bank's Iraq oil proceeds account, and it makes it clear that SOMO can't give any instructions.
Same points.
And same points.
Yep.
So those are very strong indications that as between SOMO and the CBI, it is the CBI which is entitled to the debt. But we say you are then entitled to look at the background material to see that that is in fact the position, because in entering into these contracts, Iraq was fulfilling its international obligations under the United Nations Security Council resolutions and the note verbale. And the central bank was acting in its official capacity as the Central Bank of Iraq in fulfilling Iraq's international obligations.
On your case, does CBI have a cause of action of its own?
Yes. Yes. And as I say, there's no, in the Court of Appeal, there was a dispute as to whether that promise owed to the CBI was supported by consideration or not. Well, anyway, there is no issue.
Anyway, it doesn't matter whether there was or there wasn't. There is
So
Anyway, there isn't an issue about it now, whatever.
so long as that is the construction on the face of the letter of credit, provided there is a promise to the CBI, then it is common ground, as I understand it, that it's an enforceable promise.
the absence of consideration matters no more between SOMO and as against CBI as it does against SOMO, in other words.
Yes, and it's not. It would not be a defence for Crédit Agricole. That's the point. It would not be a defence for Crédit Agricole to say that our promise to the CBI was not supported by consideration. That, as I understand it, is what is common ground for the purpose of this appeal, if not below as well. Now, we respectfully submit that on this part of the case, this second headline point, the relative entitlement to the debt, the learned judge at first instance was correct to decide this aspect of the case in favour of SOMO. And at paragraph 66 of his judgment, he said that the judgment creditor can only obtain what the judgment credit debtor could honestly deal with.
This is page 47, yes?
Yeah. Yes.
Yep.
Now, and we say that Lord Justice Morbick was wrong on this aspect because he should have held that in light of the express terms and the background material, it was the CBI in its own right for the purpose of fulfilling Iraq's international obligations and not SOMO, which was entitled to the debt due under the letter of credit. Now, Lord Justice Morbick and Mr. Pollock both say, well, it's not enough that SOMO has no interest in the funds once they hit the bank account in New York. But that is not the point I'm making. I'm saying that the terms of the letter of credit themselves and the background shows that as between the CBI and SOMO, SOMO was not entitled to this debt and it has to be paid to the CBI. And that was true from the moment that the debt was created as between the SOMO and the CBI, from the moment of creation of the debt, when the letter of credit was issued, it was CBI which had the entitlement to it and not SOMO, as between them. Now, I don't want to labour too long on the background. It's been set out, the United Nations background is set out in the Statement of Facts and Issues.
In a sense, this is the same point with added background, isn't it? That's the first point.
Well, it is the same point, but here it must be permissible to allow
Right,
the background.
I'm not saying it isn't permissible. That's not the point I'm making. It's really the same point.
It's the same background.
Plus
It's the same background, absolutely.
It's the same contract plus background.
Exactly, it is. It is. Absolutely. So,
But you can get the background in which you say, which you couldn't have got in, you would largely accept on the first point. Yeah.
So where do we go? Statement of
We
fact?
get it in the statement of facts and issues.
Where is that?
yes. So that is in the core volume 1 at tab 4.
Yeah.
Are
You must have got this just-
you sure?
yeah.
Well, electronic 2631.
Not core document, no.
It's called core volume 1.
Always as difficult to
Yes.
construe as the letter of credit.
Is
The
it-
bundling.
I think we have 4 different.
I mean, they all look the same, and they all describe themselves very similarly.
Apart from,
Yes.
it isn't part one core document, it's
It's-
been called core volume.
It's core bundle.
On Supreme Court
Anyway,
core volume.
page 2629, anyway, whatever it's
Yes,
called.
and the relevant bit that I'm talking about here is 2631.
Thank you. The international background.
And starting in paragraph 9, this is the background. So in 2003, the United Nations Security Council passed a resolution imposing sanctions on the state of Iraq, under which all the proceeds of export sales of oil by Iraq were to be paid into an account held by the CBI with the Federal Reserve Bank in New York, designated the oil proceeds account. These are agreed facts. 95% of receipts from such oil sales were to be used for a fund called the Development Fund for Iraq, and the remaining 5% was to be used for the UN Compensation Fund to provide reparations to Kuwait. In 2004, the privileges and immunities which had been afforded to the proceeds of sale of oil by Iraq were continued, except with respect to any final judgment arising from a contractual obligation entered into by Iraq after 30th of June. We didn't need to worry about that. And then on the 15th of December 2010, the United Nations decided to terminate, on the 30th of June 2011, the arrangements which had been established for depositing into the DFI the proceeds of export sales, and with it the privileges and immunities granted by the UN applicable to such receipts, although the remaining 5% still had to be used for reparations to Kuwait, for which the relevant privileges and immunities continued to apply on the basis set out in Article 27 of Resolution 1546. And then we come to the note verbal. And rather than read you that summary, I would like, if I may, to take you to the note verbal. This is in Appendix Part 3B at tab 10, Electronic 976. And it starts on page 976, page 77 in Appendix Part 3B, tab 10.
Yep.
The permanent mission of Iraq to the United Nations presents its compliments to the office of the President of the Security Council and has the honour to attach here with a letter from the Minister of Foreign Affairs and the enclosures thereto, a report of the government of Iraq regarding the transition to the successor arrangements of the Development Fund for Iraq in accordance with paragraph 4 of Security Council Resolution 1956. So what had been required in 1956 at paragraph 44 was a report on what is going to be the transition arrangements. And this was the report which contained the transition arrangements in compliance with that resolution. And if we then go over the page to 978, paragraph 1, pursuant to Security Council Resolution 1956, paragraph 4, in which it's requested that the government of Iraq provide a report to the Council no later than the 1st of May on progress towards a transition to a post-development fund mechanism, we should like to inform the Security Council that the government of Iraq has completed the arrangements that will ensure full and effective transition to such a mechanism. And these measures include, and then you see at C, they will still deduct the 5% compensation percentage or any lesser percentage, which is going to go to the ongoing reparations to Kuwait. And then in paragraph 2, with respect to the post-development fund mechanism, the government of Iraq has decided that after the 30th of June, it will continue to use the same mechanisms for the development fund for Iraq, including the following. And then it's set out in detail there. They will still have the money paid to the Central Bank of Iraq, but they will, rather than the development fund for Iraq, they have a new account, and all the money, the old money plus 95% of the new money will be transferred to the new account, but at D, 5% will continue to be transferred from the oil proceeds receipt account referred to in A above to the United Nations Compensation Fund account. That's the Kuwaiti reparations. And then those reparations are further dealt with at paragraph 6 on the following page. Concerning the deduction of the 5% compensation percentage or any other lesser percentage, the government of Iraq has decided to continue to use the same mechanism that was adopted under the Development Fund of Iraq, because that mechanism is transparent and will ensure that Iraq is able to continue to meet its obligations as provided under Security Council Resolution 1483. So the position is that Iraq was still going to use this mechanism for discharging the 5% obligation in relation to the Kuwaiti reparations. It was still going to use the central bank oil proceeds account for receiving the 95% balance, and this report, this note verbal is the report required by Article 4 of Resolution 1956. And the position in Iraqi law was mirroring of the United Nations obligations that we've seen referred to. So as I mentioned earlier, this is the law, the financial management law, which was brought in by Mr. Bremner when he was the administrator for the provisional authority following the coalition invasion of Iraq. And you'll find this in Appendix Part 2D, Tab 5, Electronic Bundle 603.
Yep.
And it's called the Coalition Provisional Authority Order 95, Financial Management Law and Public Debt Law. And if one goes to the third page, you see it's issued by Mr. Bremner on behalf of the Coalition Authority, and the relevant paragraph is paragraph 5, which is on electronic bundle page 613,
Yep.
page 103 in bundle
Yeah,
appendix part
613 is
2D.
fine, yeah. Yep.
And it starts by saying, all proceeds from the sale of petroleum or otherwise derived from current or prospective petroleum extraction, including from the federal government's production shares and royalties, and so on. And then in the fifth line, shall accrue to the budget. And then it says, except as provided in paragraph 2 of this section below, or may otherwise be required by applicable United Nations Security Council resolutions, the receipts from the export of petroleum shall be deposited into the Development Fund for Iraq account to be held in the name of the Central Bank of Iraq, or a successor account for the DFI, hereinafter generically referred to the Petroleum Revenue Account. As you can see, that's the oil proceeds account, and reflected accordingly as receipts and transfers to and from the budget. And then it refers to Resolution 1483 and the subsequent resolutions in relation to the Kuwait reparations, basically mirrors what we have seen. Then in 4, it says, in the event that a successor account, the original DFI, is established, or the original DFI is continued beyond the date of the transfer of government's authority to the Iraqi interim government, the following shall apply. And then you see that operational responsibility for the petroleum revenue account will be with the Minister of
So in a sentence, what are we getting out of all this?
Well, you're getting out of this that the central bank is the party that is entitled to receive, on behalf of Iraq, the proceeds of the sale of oil under the letter of credit, and not SOMO. SOMO, you don't see SOMO being mentioned here as having any entitlement to the proceeds of letters of credit or the sale of oil from Iraq.
But just to get it straight, these post-development fund arrangements, which you read first, that is successor arrangements after Security Council resolutions cease to apply, is that right?
Yes, well...
So this is this is just a voluntary at the international level indication that this is what the Iraqi government is going to arrange for the future. The 5% is no doubt compulsory, but it ceases to, well, I say it's no doubt compulsory, that the 5% is going to continue. Why is that? That's because it's compulsory?
Because the reparations for Kuwait still haven't been discharged, and therefore
so that part of the Security Council resolution still
that's
continues.
that's a different resolution,
yeah.
And that's continuing. The other part, you're right, it is voluntary in this sense that it was left to Iraq to devise its own transitional arrangements, but it was obliged under the resolution to have its transitional arrangements and to report on what the transitional arrangements would be. So it wasn't allowed to do anything it liked. It had to have a scheme that was acceptable to the United Nations and had to report to the United Nations as to what that scheme was going to be. But you're right, no longer did the 95% have to go into the DFI. Once it went to the oil proceeds account, it could be dealt with differently according to what the Iraqi government decided to do with it from that point in time onwards. But it wasn't. At no point in any of this is it owed to SOMO or money which is at the disposal of SOMO. Yeah. And it's paid, and so the 2 points you get out of it, answer my lord.
Well, it was owed to, originally it was SOMO's sale, and SOMO got a quid pro quo, but you say that both by the letter of credit and by this there was an agreement that the monies would go in a certain direction.
Yes. Just on SOMO, my lord, I hope there's not been a misunderstanding. SOMO is not the oil producer.
No.
It
No,
is
it's a
only
seller.
it's only a marketing organisation.
Yes.
It just enters into the international contracts to dispose of the oil.
Yes. Well, it's
So-
still, on the face of it, entitled, presumably it pays for them as well.
Well, there's no evidence about that.
Anyway, whether it pays for them or not,
It is the person that sells the oil.
yes, it sells the oil.
It sells. It sells.
So on the face of it, it's entitled to the price, but you say this amounts, what, to an international understanding as to where the price will go, but it can't be legally.
Well, there's two things.
What's legally binding, perhaps, is the letter of credit.
No, but this I'm looking at now is the Iraqi law.
Law, you say law, is it law?
Yes, it is. It is common ground. It's law. We had expert evidence about this. I'm only taking you to the law itself, but the coalition had legal authority to make law for Iraq, and this continues.
I mean,
in
this is
force.
Iraqi municipal law.
Yes.
It's not on the international plane.
No. There's two things. What I've said is there's the international plane, and then that's mirrored in Iraqi domestic law.
One can understand Paul Bremer's decision was mirrored in domestic law, but you say this post-development fund is also agreed to be effectively in some way enacted in Iraqi law. I mean,
Well, it's catered for in this. I've taken it very quickly, but it's catered for in here.
In what's here?
If it says in the event that there is a successor account, then
Sorry, wait a minute, what are you reading from now?
I'm looking at the financial management law,
Paragraph,
where's that?
paragraph 4.
section
Page?
5, paragraph 4.
Page 613,
Yes.
I see.
as I see, paragraph 4 of section 5 of the whatever this is. No, it's the
So
order number 95.
So you have the earlier resolutions, the one coming to an end, but an obligation to report, that reporting obligation being contained in the note verbal, also describing how the 5% will continue to be paid to Kuwait, and all the while that is consistent with and reflected in the Iraqi law, which I've placed before you.
Yes.
Yeah. And it may not be necessary, but in these circumstances, the note verbal is binding as a matter of international law, and we've referred to Oppenheim, which we've got in the bundle on that point, because it is the state of Iraq's public declaration as to the manner in which it will carry out its UN obligations, required by, even the reporting part was required by United Nations Security Council resolution.
Yeah.
And the relevant passage in Oppenheim is in volume 4 at tab 95.
But in the management of the petroleum revenue account, that's monies which actually hit the account, presumably. That's what's being regulated by paragraph 4 on page 603.
Yeah.
So it doesn't say anything about the arrangements in
I-
respect to monies which are hoped to hit the account.
I'm absolutely right, Michael. There's nothing in here about letters of credit as such, and I can't claim that there's anything in here that says this is the way the letters of credit have to be drawn up.
Merely the background when construing the letter of credit, at least for the purpose of your second line of argument.
Yes, and what? Yes, that's right. So, the point I'm making, just to try to draw it together and move on, is this is helpful background, including the Iraqi law, in deciding upon the respective roles of SOMO and the CBI, at the time when they entered into the letter of credit with Crédit Agricole, and at the point in time when the debt was created. Now, of course, that would be normally of no concern to the bank, but it's different for the court, because the court has to satisfy itself that in making a third-party debt order, it's not interfering with the rights of someone else. And we say that it is interfering with the rights of someone else here. Now, the cases on this are the Regeneral Horticultural Company case, ex parte White House. Mr. Pollock, I think, referred you to, but didn't take you to this morning.
Right.
Now, that is in Core Bundles tab 3, Core Authorities tab 3, Electronic Bundle page 1698.
Yep.
Now, there's a summary of the facts in Lord Justice Morbick's judgment at paragraph 25, which I can't disagree with in any way. So the facts are adequately and perfectly summarised in paragraph 25 of Lord Justice Morbick's judgment. The key passage is on page 515. Now, the background...
Which paragraph is
This
it?
is which paragraph of Lord Justice Morbick?
Oh, paragraph 25.
And it's page 1701 of the bundle. Yep. Yep. So the passage you want to go to in Mr. Justice Chitty's judgment is page 1701.
Without going through the whole of the background, very simply,
Yes.
there was a debt, and the debtor, the creditor, had made had executed two charges over that debt, one to two gentlemen and one to another gentleman. And the question was, could there be a third-party debt order in relation to the debt, notwithstanding the charges, notwithstanding, in other words, the rights of the chargees? And at 515, Mr. Justice Chitty, this is about 10 lines down, says that I see no reason why any Act of Parliament or rules of court should be so interpreted as to make a man do a dishonest act. And yet, if I were to allow Mr. Brown's argument, the judgment creditor would obtain not the property of the judgment debtor, but that of someone else. And then if you go down, you'll see about 8 lines down from there, the assignment and charge from Wills to Hillier and Seagar is binding and good as between the assignor and the assignee, and the equitable doctrine of notice only comes in as between encumbrances. And then he talked about the ranking of the encumbrances. And then he said over the page, I apply these principles broadly as against the judgment creditor who's obtained the garnishee order here, and say that he can only obtain what the judgment debtor could honestly give him. In other words, because of the arrangement between the judgment debtor and the persons in whose favour he'd executed a charge over the debt, he couldn't honestly deal with the debt, and therefore it shouldn't be made the subject of the third-party debt order.
Well, he's distinguishing the position of where notice is relevant, is he, between successive assignees. He's saying that this isn't a case of assignment, this is a case of intervention by law, and you take whatever the position is, whether they've given notice, whether the proud people of charges have given notice or not. Is that the position?
No, what he's saying is that because he had executed charges over the debt, the judgment debtor couldn't honestly assign this debt or make it available to the person to whom he was the judgment debtor. And in those circumstances, it couldn't be made the subject of a third-party debt order.
I mean, honesty really is just a red herring.
Yes.
The fact is, you can't appropriate other people's property. Full stop.
Well,
I mean, the point is the absence of notice.
The notice point is just, I think, really goes just to the ranking, the relative rankings of the absence of notice meant that it wasn't a valid equitable assignment, as I understand it.
Well, not as between the parties and a third party.
Yes. But
Not
as,
as- not
but
as
inter
against-
se, it was binding as a matter of conscience. That's I think what he's saying.
Basically saying that somebody who comes into execute is in a different position from a subsequent assignee, isn't he? Because the head note says even in the absence of notice, a subsequent intervener who gets a court order
Yes.
Can't get at this asset.
Yes, exactly. Yeah.
Yeah.
And so by parative reasoning, we're saying that's the same here for Taurus. It cannot defeat the entitlement as between SOMO and the CBI to this debt. This is obviously, if I'm wrong on the first point, just on the pure construction point, but then if you go behind and you have to inquire...
You haven't shown, or have you shown, in some miraculous way, that apart from the letter of credit, CBI has any right to this money at all. If there had been some assignment by SOMO to CBI, one could understand your point. Then it would be analogous to this case of general horticultural. But you haven't shown anything except what's in the letter of credit, have you? You've just shown us some laws which say that once it gets into the development funds or petroleum revenue account, then it's dealt with in this way and that. But you haven't shown anything which actually gives CBI a legal right under a letter of credit, apart from what the letter of credit says.
There's what's on the face of the letter of credit, and there's the background
You're going
material
round in
that I've
circles if
taken
you're
through.
relying.
There's nothing else, no.
Is that a convenient moment?
Yes, it is, yes.
Very well. We're resuming at 10:30 tomorrow, I think. Good. Thank you very much. Of course, now adjourned. We'll resume again at 10:30.